As part of the Brexit process, following the election of Boris Johnson as Prime Minister, there was a deadlock. There was a deadlock within Parliament, and to break that deadlock, there was a use of what was called prorogation, when you suspend for a short period of time the sitting of Parliament. And astonishingly, the Supreme Court, a case was brought by a woman called Gina Miller, and the arguments were put together by a man who rejoices so appropriately in the name of Lord Panic. And Lord Panic put forward an argument that the essential purpose of Parliament is to hold the government to account. Therefore, to suspend the sitting of Parliament is an affront against the basic function of Parliament. Ergo, the prorogation was illegal. And the idea that the court of law can rule against the government and Parliament exercising its own power of self-government seems to me to break the whole principle of English government since the 17th century, the whole principle of English government since the Glorious Revolution and the Bill of Rights, which declares that proceedings in Parliament are susceptible to no other court. And I was astonished that the government let it stand. I was astonished that it was ever ruled to be judicable.